Hi, how are you? Well, I'm sorry I missed you all. I wanted to leave you this video a little bit in order to kind of follow up on the lesson that I left you, talk to you a little bit about the midterm, and see where we go from here. Okay, I looked at the midterm. Some of you know I sent them back and asked you to do more. This is what I expect you to do or expected you to do in the midterm. 1, research the issues. Now, how are you going to do that? Well, I left you a variety of different questions. You had 2 options. 1 was to go to the library and begin research in the library, trying to find the answer. But the most likely one, the one that you are most used to, is to utilize online research. And online research, in this case, was Google. By the way, as an aside to all of this, I will tell you that I am in the process of giving you each a Lexis identification and password so that when we meet again, we can begin to look at Lexis as a tool for research. Now, at that time, if you have iPads or laptops, I prefer than what we have traditionally been doing, which is utilizing research with the cell phones. And part of the reason for it is that you have more geography. There is more for you to work with rather than the small screen. Apart from that, the telephones are fine, and if you don't have them, it's not a prerequisite, so don't worry about it. We may, in fact, go down to the library and do some of this work in the library. Now, what are some of the things that you should have looked at? Now, what you could have done is taken the facts, and in this case there were a lot of facts. You may recall there was a sailboat, there was a vacation, there was an injury. The injury was caused by the failure of the sailboat, the relationship between the individuals that were injured and the sailboat company. They were customers, they leased. So these are words that you should have been plugging into the search engine in order to see what you got. So a sailboat, the legal terms would have been lease, would have been customer, would have been injury, would have been a hotel and vendor or kiosk, or a beachside business. All of these things could have potentially given you a variety of different results. Unfortunately, when we're doing Google, Google is not particularized for legal research, so you're going to find a lot of other stuff that has nothing to do with cases. But within that stuff, which I'm going to call artifacts, within a lot of those artifacts, you should have found a variety of different cases. And by the way, Florida would have been another one because you're looking for Florida law, and law would have been another one. Now, through those artifacts, you should have come up with the name of some cases. In this case, a lot of you came up with Amoroso versus Freeland Family Enterprises. And in essence, the facts of your problem came out of that case. That was a case that I handled a long time ago and ultimately went to the Supreme Court. But in that case, there were a variety of issues that are very similar to the issues in this case. In particular, the relationship of or the rights of a customer who leases or rents versus a customer who buys an item. By now, some of you, if you've taken business law, know that there are certain warranties that go along with a sale. Warranties are things that the law implies dealing with the relationship of selling goods. For example, merchantability, fitness for a particular purpose, a warranty of title, are some examples of warranties that automatically apply by law to the sale of a particular item. But in this case, there's no sale, except for the sailboat. Sorry for the pun. There's no sale that takes place. There is a lease that takes place. But there's a real question as to whether a customer that leases or rents something is protected under the law less than a customer who buys. Are there warranties for leasing and renting? Traditionally, the answer was no, but Freeland Family Enterprises, the court began to say, yeah, there should be protection for these people. These people are somewhat similar to someone who's buying. And as a matter of fact, the way that people are doing business today versus 10, 15, 50 years ago has changed and evolved. And if you look at your own situation, a lot of you are leasing your cars versus buying them, because we're going to a lease situation, perhaps because there's less money around and people rent homes as opposed to buy them because of the fact that there's not enough income to be able to buy them. Another situation is you can get more in a lease situation. You can get more, meaning quality of the item is greater, value of the item is greater than when you buy it. So leasing is more of a modern trend that we're seeing, and the question of law is, should people who lease and rent be protected less? Amoroso answers that question. In this case, some of the questions that we had, for example, were, what cause of action? Well, among the causes of action, there could have been a breach of warranty. A breach of warranty, which would have been a traditional contract remedy or sales remedy. There is negligence that could also be attributed here. Under a breach of warranty, for example, the standard is different than negligence because it's a strict liability standard. Strict liability is where the provider, in the case of sale of goods, sells an item that he manufactures, he warrants, he ensures that those goods are going to be fit for the purpose that were intended. And if they're not, he's going to be held strictly liable no matter how much care he took into it. There's a strict liability if you manufacture something and somebody gets injured because you benefit from that manufacturing of an item, you're going to be strictly liable. Well, in this case, the Supreme Court of the state of Florida said that there was a strict liability for a breach of warranty of fitness for a particular purpose. The particular purpose was the sailboat was intended to sail. And when it failed, the lessor, in this case the kiosk, and then as an aside, the Diplomat Hotel, were going to be held to that standard. Aside from that, something else you should have come up with was there is a certain degree of negligence of a manufacturing, or in this case was a manufacturer, of repairing something in a negligent fashion that ultimately failed and somebody was injured as a consequence. So those are your theories of recovery. Those were your reasons to sue, causes of action. All those things that I've just said are synonymous with each other. Who you can sue? Well, the kiosk, clearly, you could sue because they were the ones that actually established the relationship. You went there, you leased it, you rented it from them. They were the responsible party for putting it in the stream of commerce. Two, they were also responsible because they were the ones that sent out the sailboat to be repaired, ultimately repaired negligently because it was not effective. Possibly the welder that welded the sail because the welder didn't weld it correctly because it failed. Two, maybe if he did weld it correctly, he should have been in the position to say, hey, the amount of stress that's involved here, you shouldn't weld it at all. And the big question, the big issue was, can you sue the diplomat? And I gave you sufficient things in the facts to suggest that there was a relationship, an alter ego relationship between the kiosk and the Diplomat Hotel. And I gave you facts such as, you could lease it it would appear on your bill, you could leave your keys, you can make a telephone call, there was information in the room. So it did appear to the customer, in this case, the people who patronize the Diplomat Hotel, the guests, and there appeared to be a relationship, and therefore the Diplomat should be prevented from saying, no, there's no relationship, we had nothing to do with them. Because you and I know that but for the relationship with the Diplomat, the amorosos, in this case, the customers, would never have leased this item. So those are things that you should have taken into consideration in your midterm. Hopefully you did. At the moment that I'm taping this, I haven't reviewed and I haven't checked your midterms because I've given you all this time to go ahead and do it. For some of you, you've turned them in, I turned them back to you, and you turn them in, I turn them right back to you, because I want you to get it right. The idea of this midterm not only is a grading opportunity for me and for you, but it's also a learning opportunity, and the learning is much more valuable. I want you to get it right. So if I've sent it back, it's with the intention of you reassessing it and getting it back. Now, with tonight's assignment, the assignment that you are to do a Monday night, tonight's assignment is an assignment that is based on going out and finding a case. What is a case? A case is what we utilize, or the name that we give, to a determination by generally an appellate court. The appellate courts take a real-life controversy, and what I mean that is two or more people have come to the court with a real-life problem and asked the court to give a solution. A solution was given, and ultimately it arrived at an appellate court with a question. Generally the question is the trial court, the court below. If it's an appellate court, it's the trial court. If it's the Supreme Court, sometimes it's the appellate court. The court below made an error. And we want the court that is reviewing this, the appellate court, which are the ones that are writing the opinion, to review, to make sure that the error is corrected. That's what the appellant says. So that's what a case is. And once it is decided, as you know, it becomes part of our common law. It becomes judge-made law. Other judges that are inferior, because remember that we have a hierarchy. The appellate judges rule and the trial judges have to follow those rulings. The Supreme Court rules, the appellate judges have to follow the ruling, trial courts have to follow the ruling. So when a case is dictated, judges that are in courts that are inferior to the court that gives the determination have to follow what the appellate courts say. So it has, a case has the power of law. So what you're doing is what's called a student brief or a case brief, depending on your utilization and whether or not you're a student. Now, I do need to tell you that there's a variety of different formats that are used throughout. And your book says that there is as many formats as there's lawyers out there, and that's true. Because at the core, what a brief is, it is an outline of the case. Now, the first thing and the primordial thing and the most important thing, and what I should underline and hold you by the shoulders and say you need to do this, is you need to read the case. You need to read the case. There's no shortcut. You can't brief if you don't read, because a brief is an outline of the case, and it is your outline of the case. You have to read it. And you have to do something even more complicated. You have to try to understand it. Once you've read it and you try to understand it, and I suggest that you read the case before you start the briefing process. Don't start putting pen to paper until you've read it at least once. When you read the case the second time, now you're going to be looking for specific information. And I've already given you in the paperwork that I've sent the specific information, so I'll go over very quickly. The style, the facts, the issue, the holding, the reasoning, and the rule of law. Look at the paper that I sent with you under different cover for an explanation for those things. Your assignment is to find a case. I don't care what case it is, and brief it. You're going to brief it. Now, I do know that there are web sites that give you briefs that are done. Number one,